Hi there, folks. This is Sam Price, and we're going to do another episode of Probate Notes. Today, I have a very special guest. He is going to give us some very good insights about working with the public administrator. So I'd like to welcome attorney Shane Duncombe to the show. Hi, Shane. Thanks for being here.
Thanks, Sam. Really excited to be here. I'm a big fan of your podcast. I'm super excited that we've got a member of the bar doing this. I think it's great. So I appreciate the opportunity. Thank you.
Thanks. I've been looking forward to our conversation. And before we start talking about the public administrator, can I just get a little feel for your background?
Sure. So I went to school originally out of high school for a marketing degree, and that market was pretty saturated. So I spent some time kind of trying to figure out what I wanted to do. And then I went to law school a little bit later. So I got to get some life experience and work a couple different jobs and work at human resources. And that kind of drove me towards wanting to get into law, as well as my mom telling me when I was very young that most attorneys are jerks and never to be one. So that rebellious side of me wanted to see what it was like and so forth. So got into law school. I graduated top of my class. I was elected as valedictorian for my class as well. And
Where did you go to law school?
California Southern Law School in
Excellent,
downtown Riverside.
Yeah, incredible.
Yeah, thank you. So, and then I interned while I was in law school for a professor of mine, and then I switched over to working with Jeremiah Raxter, my predecessor at my law firm, and he went on to greener pastures, I suppose. And now I own my own law firm, Duncombe Law PA, and get to work with two different counties, public administrators, the San Bernardino and the Riverside. As well as do a lot of different private cases and do a lot of probate work and civil litigation. So,
did you start out doing trust and estate work?
I did with Jeremiah Raxter as an intern, since primarily he was focused on probate. He was also working with the public administrator at the time. And I also did a little bit of civil litigation here and there just to kind of get a feel for civil procedure and contract laws, real estate, and so forth to try and stay well-rounded for the probate side. But I haven't really dabbled outside of that too much. Did a couple family law cases, decided very quickly that wasn't the right path for me.
Yeah, I don't blame you.
Yeah. But yeah, I haven't really ventured outside of the civil world though. So.
What should I, as an attorney, be doing if I'm representing a private party in the case?
Well, it depends on what your client's goals and objectives are, and what the purpose of that order to show cause. So, I would say that in most cases, it's because there's something that your client can't get over, whether it's a certain procedure or it's a problem they've run into. So really, once an order to show cause is issued, the public administrator generally will go out and start investigating the issue. So as the attorney, your cooperation in facilitating any sort of information that can be handed over, certainly outside of work product or attorney-client privilege issues, certainly that cooperation does help in making sure that the probate court is informed, the public administrator is informed, and then the right decisions can be made from there.
Gotcha. And should I be filing anything with the court?
You definitely should file a declaration or a response to the order to show cause on behalf of your client. I think that's important to explain to the court what your client and your position is in relation to whatever the issue is. If it's a lack of communication, or if like I said, your clients run into an issue that's rendered administration impractical for them, certainly that explanation, so that way your client doesn't incur any sort of liabilities also, not being able to proceed forth with the administration.
Have you noticed any kind of like standards when you're splitting fees with the attorney or the personal representative of how fees are split depending upon where in the administration the public administrator is appointed?
So From my perspective, it's usually looking at the amount of work that was done by the previous attorney in the matter versus the amount of work that I've done in the matter. Sometimes I've done a comparison of how many hours we've put in. Even though we're not billing by the hour, we're still tracking it to make sure that I can make those types of comparisons. Oftentimes if we're coming in right at the end to wrap something up, we'll just kind of apportion it based off of, what the other attorney tells me that they're doing and so forth. Sometimes though, when a party is removed, whether it's through the fault of their attorney or through the personal representative, sometimes that's a harder discussion, because did they really, through the administrative work that they did, actually confer any benefits to the estate? And then it's a question on whether or not those fees should be split or not. And so every case is a little different. It's going to be dependent on the facts, and there isn't really a standard practice or hey, this is our normal procedure for every single case. So,
Does the public administrator typically liquidate everything to cash, or do they do any type of in-kind distributions?
so every case is different. The typical lawyer answer, but
Yeah.
you know, uh, in looking at certain types of properties, usually liquidation is more equitable. Because we're looking at for example, a home. If one beneficiary is living in there, and there's more than one beneficiary in the estate, and they're not enjoying the benefit of living there, then really what's more equitable? Selling and distribution of the cash, or distributing it in kind and allowing that one beneficiary to enjoy a benefit that the others are not. And maybe that's okay in a private circumstance. You get agreement with the beneficiaries, but the public administrator again doesn't have those familial ties. They don't have the history of everybody, so usually they look at it from a pure fiduciary standpoint. What's going to be most equitable to everybody involved, and normally that requires liquidation, or will warrant liquidation in those circumstances. And in addition to, we have to make sure that there's enough liquid assets to pay for all of the costs. Since the public administrator has that minimum, we have to make sure that the state's solvent enough to be able to pay those, and certainly all of the different creditors and so forth that might pop up. So a lot of times liquidation is warranted with the assets, but certainly in cases we've had beneficiaries request in-kind distributions, and some of those had been done in the past. It certainly isn't a policy that they don't do in-kind distributions. It's just usually equity kind of demands that. So,
Are there any unique challenges in representing the public administrator that are different from representing a private party?
so I say yes, absolutely. The unique challenges, kind of what I've mentioned before, are like the lack of familial connections, and personal knowledge. When a decedent dies, all they know is what's been told of them, or what they receive as far as the decedent's remains, or whatever property was on them at the time. And so they have to go and investigate everything. Now, with my experience with private clients, it's a lot of guiding on, okay, well, let's go try this, let's go try that. Whereas with the public administrator, they've done this 1,000 times before, so they know what to look for, where to look, and certainly that experience helps expedite that process a little bit. But some of the other unique challenges is really stepping in and trying to be the fix of a problem. Where I might substitute into a matter halfway through, and so really it's just a matter of me getting up to speed and then continuing on. Whereas here it's getting up to speed and then figuring out everybody's position, and then trying to fix that. And say, okay, how do we get Bob over here and Sally over here to agree on whatever the dispute is, and how do we do it in a way that we stay neutral, that the public administrator can move forward in administering the estate. And sometimes the challenges that Bob and Sally, for example, might present as far as a solution, some of the challenge is the public administrator can't do that. We can't necessarily create a trust and then manage that for many years going forward. Statutory, or it's precluded by statute. So a solution might not be on the table that it would be in a private circumstance. Now, certainly there's workarounds and things like that, but Those are some of the various challenges that I've run into that certainly are different than a private client.